This is important, really. The way I see it, what I heard today, the J6 prosecution against Trump is getting gutted within the next 2 months. I counted 6-3. I counted 6. Chief Justice Roberts seemed firmly against the government on trying to turn what was a charge meant to punish entities like Arthur Anderson, which shredded documents after it had received a subpoena or when it knew it was about to, from doing that into something that would swoop up hundreds of J6 defendants who randomly found themselves on the Capitol that day. So here's what happened. Small town cop, Joseph Fisher, spent about 4 minutes inside the Capitol building, joined the crowd breaching the Capitol from the east side. He yelled again and again, "Charge," the government says, before pushing forward toward a police line while yelling, "Mother effers." He and other rioters fell to the ground after other rioters lifted him up. Video disclosed as evidence shows that he tried to appeal to officers protecting the Capitol, telling them that he was an officer too. "It's our effing house, brother," the video appears to show Fisher saying that day. It's also on his social media as of the next day, January 7th, Fisher writing that he had been pepperballed and pepper sprayed, but entry into the Capitol was needed to send a message that we the people hold the real power. Okay, not surprisingly, this guy got charged. He was charged with 7 criminal counts, including a felony count of obstructing an official proceeding. He also got charged with assaulting a cop and entering a restricted building, et cetera, et cetera. But this whole case is about obstructing an official proceeding. And it is also the main charge against Donald Trump in that DC federal prosecution. What happened was the district court judge, as a trial court judge, Carl Nichols, ruled that this charge could not stand, that this was not, it didn't fit the behavior that they were alleging against Fisher. This is not what this charge was meant to cover. It's section 1512C1, prohibits tampering with evidence with the intent to impair the object's integrity or availability for use in official proceeding. And then there's 1512C2, which says, I'll get to it, but basically has wider language saying somebody who, with corrupt intent, otherwise obstructs, influences, or impedes any official proceeding, or attempts to, Justice Sotomayor. So they're kind of looking back to Arthur Anderson saying this law was meant to get after financial fraud or like interference with an official proceeding by somebody who's in financial trouble, who shreds documents or tries to intimidate a witness into not testifying. And the otherwise provision is meant to only say, okay, you sub 1 says you can't alter, destroy, mutilate, or conceal a record, a document, or other object, or attempt to. And then sub 2 says, or otherwise obstruct. And what the defense is arguing here is that second clause doesn't expand this statute to cover any kind of obstruction of an official proceeding. It's all still under the lane of records, documents, other objects that get destroyed, mutilated, or something like that. That's what they're trying to argue. It has to still be in the lane of, it's like a financial fraud or cover-up or interference when you get a subpoena in this lane. And the government's trying to say, no, sub 2, which says, or otherwise obstruct, covers everything. Everything. It's a catch-all that's meant to just get all kinds of behavior, including what we saw in J6. That's what it comes down to. Well, what happened today was the lawyer for the defendant, Mr. Fisher, got up there, made a very brief argument along the lines of what I just said. It's very limited, should be limited. You can't expand it. And he got a couple of questions from, like I said, Sotomayor and some of the more liberal jurists. There's only three now, which were fine. I mean, to me, honestly, like half of them were just confusing. I'm like, I don't even understand what they're asking, these ladies. But okay. And he did okay. I give that guy like a B. Then the Solicitor General gets up. She represents the government, and she started getting peppered with questions by the conservative jurists almost right away. And not surprisingly, Thomas, he was right off the bat. He laid into her on when the hell has this otherwise provision ever been applied to protesters? Has that ever happened before, or is this just a Donald Trump J6 thing? Here's a little bit of that in SOT 11.
There have been many violent protests that have interfered with proceedings. Has the government applied this provision to other protests in the past? And has this been the government's position throughout the lifespan of the statute?
It has certainly been the government's position since the enactment of 1512C2 that it covers the myriad forms of obstructing an official proceeding and that it's not limited to some kind of evidence impairment gloss.
Have you enforced it in that manner?
We have enforced it in a variety of prosecutions that don't focus on evidence tampering. Now, I can't give you an example of enforcing it in a situation where people have violently stormed a building in order to prevent an official proceeding, a specified one, from occurring.
So what role does C1 play in your analysis?
So we understand 1512C to split up the world of obstructive conduct of an official proceeding into the C1 offense and into C2. C1 covers everything it enumerates. It's the acts of altering, concealing, destroying records, documents, or other objects. And then C2 would only pick up conduct that obstructs an official proceeding in a different way.
Mm-hmm. Okay. So you get the gist, right? Thomas is not buying it. He's like, what? I mean, look, you guys, look what happened to Kavanaugh. Look what happened when Kavanaugh was, I don't even mean the death threats, the attempted murder. I mean, when he was sitting for his confirmation hearing. Look what the Democrats did to him on Capitol Hill. Was that not obstruction of that's what he's going for.
Right? Yeah. It's exactly right. Go ahead.
Well, if I was Clarence Thomas, I would have put it a little bit more succinctly. I would have said, so, counselor, if somebody stood up right now and started protesting here at the United States Supreme Court, would they be charged with this offense?
Yeah.
You know what, Duncan?
This is an official proceeding.
You're accepted under the U.S. Supreme Court because Justice Alito went exactly there. You're now in the running toward becoming America's next Supreme Court justice. Take a listen to Alito
President
in
Kelly
SOT 6.
will get you.
Yeah.
I will. I'll nominate you. Stand by.
So we've had a number of protests in the courtroom. Let's say that today, while you're arguing or Mr. Green is arguing, 5 people get up, one after the other, and they shout either keep the January 6th insurrectionists in jail or free the January 6th patriots. And as a result of this, our police officers have to remove them forcibly from the courtroom. And let's say we have to it delays the proceeding for 5 minutes. So would that be a violation of 1512C2?
I think it would be difficult for the government to prove that.
Why?
At the outset, we don't think that 1512C2 picks up minimal, de minimis, minor interferences. We think that the term obstruct on its face connotes a meaningful interference with the proceeding.
Well, it doesn't say, I'm sorry, C2 does not refer just to obstruct. It says obstructs, influences, or impedes. Impedes is something less than obstructs.
I think that this is a verb phrase where iteration was obviously afoot, and impedes is also thought of as
meaning. You're preaching the plain meaning interpretation of this provision. The plain meaning of impede in Webster's is to interfere with or get in the way of the progress. Why wouldn't that fall within? Now, you could say, well, we're not going to prosecute that. Why isn't that a violation of 1512C2?
We read the actus reus more narrowly.
You guys get it? Duncan?
That's why the Supreme Court is so important. I mean, that right there is a perfect distillation of why the Supreme Court is so important. When, like Ashbrook said, you've got these prosecutors who are getting bought and put in place by Soros and other left-wing billionaires across the country because they know voters don't want to legalize crime. So they say, why not just have the prosecutor not do it? And that's the same thing that they are attempting to do with the Supreme Court is they want to legislate from the bench. For so long, they had a complete lockdown on having their way, whether it was legal or not, the reason Roe existed for so many years. And now they're faced with a court that follows the letter of the law. And that's what drives them nuts because that's the only thing standing between them and complete control at this point.
Yeah, I mean, it's a perfect illustration between the difference of liberal, progressive legal theory and conservative, strict constructionists.
Yes.
Right? I mean, because what they're talking about, and believe me, I'm very much a Holiday Inn Express lawyer. Like my best resume is that I had 2 parents that were attorneys. So that's like all I can do. But all that being said, they're talking about the original intent of the statute.
Yeah,
right?
the plain meaning.
Because if you're just somebody off the street and you say obstruction of an official proceeding, clearly there was an official proceeding and clearly it was obstructed. Okay, that's fine, well and good. But when you get into a court of law, the people who follow these sort of things, they're like, okay, well, here's what that statute has been used for. This is what it was intended to do. here's what you are suggesting, and here's the far-reaching, cataclysmic type prosecution event that it would cause if we were to find in your favor. Meaning,
That's it,
like
Holmes.
anyone,
And what he was saying was, you just nailed it exactly. First of all, and second of all, what he was saying was the absurdity. Like, this is somebody standing up here and yelling something could fall within this, and they could get prosecuted. And her defense, realizing she'd been caught by, her very broad definition of this otherwise provision, has her caught in a very unreasonable interpretation of the statute. She said, oh, well, that would be de minimis. This would be a small thing. And I think there's really de minimis acts clearly wouldn't be covered by this. And he was like, hold on a second. Now you're asking us to read new terms into this provision. There's nothing about the level of intrusion or instruction, right? Like, he's like, this is where your crazy ass interpretation would take us. And there isn't something in here that would say, oh, but de minimis acts don't count.
Right. She's allowed to interpret things broadly where it helps her, and it's more narrow where it doesn't help her. I mean, this is like, what about an official what's the definition of an official proceeding? How about like an ambulance trying to cross the Golden Gate Bridge while a bunch of Hamas protesters were blocking it yesterday? How about 5,000 people trying to get to their airplanes at Chicago O'Hare Airport yesterday after paying $1,000 a ticket or whatever you have to pay to fly on an airline in this country? Like, how about the obstruction of those people? Like, at what point? What's an official act? What's an official event? Is an official event
How about burning down a police station?
Well, that's
that seems pretty official.
Let me tell you a story about a guy named Leo Grillo. Leo was on a road trip and came across a Doberman. This dog was severely underweight and clearly in trouble. Leo rescued the dog and named him Delta. Sadly, Delta was just one of many animals that needed help. And this inspired Leo to start Delta Rescue, the largest no-kill, care-for-life animal sanctuary in the world. They've rescued thousands of dogs, cats, horses too, from the wilderness, and they provide their animals with shelter, love, safety, a home. April marks 45 years since Leo rescued Delta. Delta Rescue relies solely on contributions to keep going. If you would like caring for these animals to be part of your legacy, speak with your estate planner, because there are tax benefits here too. You can grow your estate while letting your love for animals live well into the future. Check out the estate planning tab on their website to learn more and speak with your advisor. We call dog a man's best friend for a reason. You can help those who need it most. Visit deltarescue.org today to learn more. deltarescue.org. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.